You're listening to WSTU Stuart.
This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. This is Stuart Address for Ask a Lawyer, and it's October 8th, 2021. We are getting closer to the end of the year, and a terrifying date on December 27th. We'll leave that as a mystery for now, if it is still a mystery to anybody.
Yeah, that's terrifying. All right.
And Greg, I can hear you, but only very softly.
That's because I was whispering.
Good, you keep it at a whisper. So let me tell you something. Yesterday, I received a telephone call regarding a flood in an apartment and inquiring of the tenant's rights. As I began to explain the tenant's basic rights under Florida's landlord-tenant law, I learned that the caller was from Georgia. I stopped, explained that I was unfamiliar with Georgia statute, and explained that the basic broad strokes between the statutes were probably similar, but that procedures and substantive rights might be very different. Now, that's an excellent illustration of why you should only speak with an attorney familiar with your state's laws. I've had clients and prospective clients tell me that they spoke with such and such, who is an attorney, and pick the name of the state. He says, she says, and that's all very well and good when somebody is giving you some basic advice and tells you to go talk to an attorney in your home state. But if that person doesn't tell you that you should consult with somebody in your home state, then he or she is a chucklehead. You should never listen to an attorney who is not a member of the bar of your state. That person cannot possibly know the intricacies of any aspect of law in your home state. So, while some landlord and tenant laws are in fact consistent from state to state, a number of states have differences. Some states have odd provisions, and it can make things difficult for everybody. Now, the goal of these landlord-tenant statutes is to give everyone fair access to housing, to help organize urban areas, and to protect both landlords and tenants. But while the goals are the same for everyone, there are plenty of laws that miss the mark and simply complicate the issues for everybody. And we have Gloria on line one.
Go ahead, Gloria.
Good morning, Mr. Address.
Good morning, Gloria.
My name is Gloria Frito, and I have a question for you.
Well, I will try to answer it for you.
Oh, I have a niece who rents a house with her boyfriend, and they had a fight, and he moved out. They both signed the lease, but he says as long as he is not living there, he is not paying rent or utilities. Isn't he responsible, being that both names are on the lease?
All right, well, you know, the lease is the master of everything. The lease is going to govern it. And of course, I would want to review the lease, but we have two possibilities here, one very likely and one less likely. The most likely possibility is that they both sign the lease as co-signers. The lease is in both of their names. And in that situation, the landlord is entitled to the full rent, regardless of whether one of the tenants moves out. And if the remaining tenant can't come up with the full rent, then they are subject to an eviction action. If the remaining tenant can somehow come up with the full rent, they then have a cause of action against the abandoning tenant. And that's where it gets complicated and messy. You know, the landlord can sue either or both of the tenants who signed the lease. The remaining tenant who was not in default can also go after the abandoning tenant. But if they both signed it equally, and there is no provision in the lease that says, well, if one of you leaves, you know, the other one's only responsible for half the rent, then the remaining tenant has a full rent obligation. Now, the other possibility, which is less likely, but often occurs in college towns, is that the landlord had them sign the lease as co-tenants, but responsible only for, let's say, their 50% share, or if there were three of them, their 1/3 share, et cetera, et cetera. In that situation, where one tenant defaults or abandons the premises, the other one is only responsible for what they agreed to be responsible. And the landlord cannot move to evict somebody who is not in default. But I suspect that it is more likely the former type of lease than the latter, and that the remaining tenant will be legally entitled, obligated, I should say, to the landlord for everything. And they can then go after the defaulting tenant, the boyfriend, if they wanted to, in probably a small claims court action. Does that answer your question, Gloria? Gloria, you still there? Gloria
Well,
hung up.
She must have hung up. She was
Well, then
listening.
I'm going to play a little bit of What's My Line with Gloria, and I'll play the part of the questioning panel, and I'll play Gloria's part as the surprise or mysterious, you know, celebrity or sports figure or caller in this case. And let's see if we can discover who it was. Gloria, did you know me in the latter quarter of 1960? Well, yes, I actually did. Gloria, have you known me and been with me most of my life? Well, I would have to say yes to that. Gloria, are you one of my parents? Well, I guess I am. Gloria, you're my mom. And you hung up on me. Shame, shame, shame. That was a surprise call from Gloria, AKA my mom.
That was your mother?
What was that?
That was your mother?
That was my mother, Greg.
Okay.
I think I answered her question, but I don't think that she is very happy with the answer.
Yeah,
I'll have to discuss that further later on.
that sounds like a terrible situation. I mean,
It
well,
is.
you know, and a boyfriend, girlfriend, like buying a house or something like that. I hear that a lot. And you think, oh, brother.
Right. You should always be careful when you sign something with somebody, particularly with whom you are not family, and you are agreeing to be responsible if they don't live up to their obligations. Because I have, in 36 years of practicing law and trying to get it right. That's why we practice. I have seen a lot of these situations. In fact, we discussed this case on a couple of shows over 4 years, but I'll quickly divert. When I was practicing in New Jersey, I had a case where parents had a long-standing family home, couple generations. They wanted to give it to their daughter who was about to get married, and they were smart. They wanted to be careful, so they made the daughter and the prospective son-in-law sign a contract that if the kids were divorced within 3 years, then they would both quit claim their interests back to the parents. What the well-intentioned parents didn't understand was that that contract was not going to survive the closing. And so when after 2 years, the parties prepared to get divorced, the daughter quit claimed her interest back to the parents, but the now son-in-law refused. And we had a week-long trial on that. And I'll be honest with you, I should have lost that case because the law was on the side of the boyfriend. I mean, the son-in-law, because the contract did not survive the closing. Closing on residential real estate, you have to have all the terms in the closing documents. You can't have a pre-existing document that survives, okay? It dies with the closing. So that contract that was signed legally didn't exist anymore. So the son-in-law should have won. But I wove some magic, and this is the case where in closing argument, the other attorney, to make the point very clear that I was trying to jump and dance and weave and bob. He said, well, Judge, if it looks like a duck, it quacks like a duck, it walks like a duck, it's a duck. And I don't know where the thought came from. I don't even think I had known the word before. But somewhere out of the depths of my brain came the response, well, Judge, that's true, unless it's a platypus. We won. So there is danger here if you're not very careful.
So you lost, but you won.
Well, I should have lost, but I did win.
Yeah. I love it.
And that's also a reason why, if you're going to a trial, you should never be cocky, whether you're the attorney or you're the plaintiff or the defendant, because you never know what's going to happen at trial. Any good trial attorney will tell you that he or she has lost cases that they believe they should have won. And won cases they believe they should have lost.
I may have asked you this before, but would you rather have a judge in your trial decide it or a jury?
Whether I'd rather have a judge or a jury decide my case, that very much depends upon the case and the nature of my client. For example, if I have a sexual harassment case full of lots of juicy testimony and things that I think are going to anger the average juror, I want a jury deciding the case because I want to up the damages award. The judge may still give me the win, but the judge is not going to be moved by the emotion and the damages are going to be suppressed. If I have a technical legal case, I'd rather have a judge decide it because the judge will understand it. And if the judge doesn't understand some aspect of it, the judge will ask questions. The jury may very well not understand the intricacies of what I'm trying to express, may not know enough to ask the right questions, or even though jurors are now allowed to ask questions, most ask very few. So if it's lost on the jury, I'm more likely to lose. So it really depends upon the type of case, the type of testimony, and whether I think my client is going to come across as credible and somebody with whom a jury could sympathize when I decide whether to recommend, we demand a trial by jury, or you don't say that in the complaint, and if the other side doesn't say it, then it's a bench trial. And I hope that answers Greg's question.
Yes, it does.
Okay, so now talking about the landlord-tenant laws, there is, in fact, a uniform Residential Landlord and Tenant Act of 1972. It was intended to solve the problem of different states and different rules. However, only a few states have actually enacted it. And so for most of the states, that is not the law. The law is whatever their statute says the law is.
Can't the federal government force them to have a blanket rule that makes sense around the country?
No, because in our democracy, there's the concept of federalism and states' rights. And if you look at it realistically, each state is its own government. Each state essentially is its own country. And what we have done here in the United States of America is we have come together as a confederation of states that have a federal government, the United States. The Soviet Union was also a confederation of a number of states, Russia, Ukraine, etc. And they came together as the Soviet Union. When the Soviet Union collapsed, you had big bad Russia, and you had a lot of smaller states. If this country ever collapses, I never would have thought it possible, then we will have 50 countries, some much more powerful than others, and we'll see what kind of a mess we create and whether we need a Brexit. So, no, you can't, the federal government can't just by fiat determine anything it wants. The federal government does, however, have tremendous power when it comes to public safety, public health and safety, because then it can enact a law and it could include in that law a supremacy clause. And that supremacy clause basically says to the states, we, the federal government, take control over this issue, and you may have laws that are more liberal than we demand, but you cannot go less than we provide. And so there, the federal government takes control as much as it can over the states. Now, it can do that, in air travel, logically, it's clear why. I mean, each state can't cover air travel. Otherwise, a plane might have to go from 50,000 feet to 40,000 to 20,000 to 35,000, depending upon whose airspace it's in. That's a federal issue. That's why we became a confederation of states into one country. But Congress could not write, let's say, a statute for the entire country on abortion. Abortion is not one of those principles that would be considered, the province of a centralized government, not in a democracy. So the only arm of the federal government who can create law, essentially, or interpret it, would be the Supreme Court. And of course, the Supreme Court in Roe v. Wade determined that abortion was going to be freely available. Most likely sometime next year, I think that's going to go away. And there will no longer be Roe v. Wade. There will be every state doing whatever the heck it wants, like Texas has tried to do and has been enjoined against doing temporarily. And people will go from one state to another for things like abortion.
Never happen. It won't happen.
What won't happen?
Roe v. Wade is a law.
You don't think the 6-3 conservative majority on the Supreme Court will vote at least 5-4 to overturn Roe v. Wade?
I think you might be surprised.
Well, I hope I am surprised. I've thought about it and I thought I might be surprised, but I really only see one of the now 6 conservative jurists as a likely possibility to say, well, I agree that, abortion should be illegal, but this is longstanding precedent. And therefore, in believing in the precedent of the court and not lightly overturning it, I'm going to vote on the side of the liberals and make it a 5-4 decision in which Roe v. Wade still loses. We would have to get, and I say we because I'm on the liberal wing, we would have to get 2 of the 6 justices to say, well, I may believe that, abortion should be illegal, but Roe v. Wade is so established in our law that I'm going to vote in favor of precedent, regardless of what I personally believe the law should be or is. I can see Chief Justice Roberts doing that. He's gone with the liberals several times last term on areas where his legal analysis from history is different than how he voted. And these were votes were in areas where the court had precedent. So I can see that. Whether any of the other conservative jurists will do that, I certainly hope they will. I'm afraid they won't. And I'm afraid that as much as Trumpism has torn this country apart, if Roe v. Wade is overturned, frankly, I think the women of this country and maybe at least half the men may seek to overturn the government. And I don't know if I'm being facetious or not.
Have you seen the stuff on Facebook, Save the Women of Afghanistan and Texas?
Gosh, no, I haven't.
It's really sick.
I don't want to. So here are a few examples of unusual aspects of landlord-tenant laws in different states. And where applicable, we'll discuss Florida as well. In Ohio and Massachusetts, landlords must keep security deposits in an interest-bearing account and pay tenants 5% interest annually. In Florida, that's optional. In Seattle, Washington, landlords are required to rent properties on a first-come, first-served basis, meaning that the first qualified applicant must get the property. That's their effort to avoid discrimination. San Francisco, California, under certain circumstances, it's legal for landlords to evict tenants to take that rental property as their own residence. But the landlord now intends to reside. It will no longer be a rental property. They can kick the tenants out. In other states, they can do that, but only upon 60 days notice, 90 days notice, 120 days notice. You can't do that in Florida. In Florida, there are only 4 ways a landlord can regain possession of a rental property: eviction, surrender, abandonment, and death. That's it. Now, New York. Some tenants are legally given the right to sublet to a roommate. In Florida, tenants are not banned from subletting unless there's a clause in their lease, a written contract, that says it's not allowed. However, even when a lease states that a tenant may not sublet without the explicit approval of the landlord. And a lot of leases say that. Even when a lease says that, by precedent, it's been determined in Florida, the landlord must always agree to the sublease if it's reasonable. So they cannot unreasonably refuse a sublet. Arkansas and Vermont. Tenants both sign a one-year lease. They're keeping a good relationship with their landlords. All of a sudden, the air conditioning system of their apartment breaks down and needs some maintenance. They both send formal notices to their landlords to get the issue addressed. But their efforts are in vain. In Vermont, the tenant was able to withhold rent to force the landlord to get the issue fixed. But in Arkansas, the tenant was forced to pay the rent even after he had told the landlord of the crucial issues that needed repair. Why the difference? Different statutes. One was more landlord friendly, one was more tenant friendly. Now, last night, in my research following that call to my law firm from Georgia, I discovered that in this area, the rule was the same for Florida and Georgia. Oh, I'm sorry, the rule is different. In Florida, after a proper notice of substantial uninhabitability of all or a substantial portion of the rented premises, the tenant may withhold rent. In Georgia, there is no such right in the statute. So when I suggested to this person, you should send a notice to the landlord, say that the premises are substantially uninhabitable, and that you are going to withhold rent until it's repaired. Well, luckily I caught myself when I realized they were in Georgia and said, but that may not be the law in Georgia. Because as it turns out, it's not. Continuing on with the repair concept. In Florida, if a lease affirmatively and expressly places the obligation of specific types of repairs onto the landlord, and the landlord has failed or refused to comply with necessary repairs, rendering the leased premises wholly uninhabitable, then the tenant may withhold rent after written notice to the landlord. Now, in Florida, we have a very, very, very specific statute. A very specific statute that tenants have to follow by the letter. And if they don't, they're not going to get the rights that the statute provides them. And that's where lawyers come in handy. So I'm going to be very specific because the statute is. In Florida, in this type of a situation, the statute says that the tenant shall serve the landlord with a written notice declaring the premises to be wholly untenable, giving the landlord at least 20 days to make the specifically described repairs or maintenance, and stating that the tenant will withhold rent for the next rental period and thereafter until the repair or maintenance has been performed. Now, the lease can provide for a longer or a shorter period of time for repairs or maintenance. And once the landlord has complied, the amount of rent withheld must be paid. Now, as for terminating the entire lease, because the premises have become substantially or wholly uninhabitable, Florida statute is very, very clear here too. It says that if a landlord materially fails to comply with notice, then within 7 days after delivery of a separate written notice by the tenant, specifying the non-compliance and indicating the intention of the tenant to terminate the rental agreement by reason thereof. You know, lawyers wrote that. The tenant may then terminate the rental agreement. But it's not so black and white, because the statute then goes on to talk about an exception. It says that if the landlord's failure to complete the repairs in that timely fashion was due to causes beyond the control of the landlord, and the landlord has made and continues to make every reasonable effort to correct the failure to comply, the rental agreement may be terminated only as follows. That's in the statute. A, if the landlord's failure to comply renders the dwelling unit wholly untenantable and the tenant actually vacates, the tenant will not be liable for rent during the period that the dwelling was uninhabitable. B, if the landlord's failure to comply does not render the dwelling wholly uninhabitable and the tenant remains in occupancy, the rent for the period of noncompliance shall be reduced by an amount in proportion to the loss of the rental value. So if half the place can't be lived in and you decide to stay, then you only are obligated for half the rent during that period of time. Very detailed provisions in the Florida statute as to the notice you have to give, what has to be done during that notice period, can that notice period be modified, and when can you actually terminate the lease, or when are you just relieved of rent responsibility for the period of time that the premises have been wholly or partially uninhabitable. So, I'm not trying to make money here, although I'm a lawyer. My advice to anybody who rents the premises, rents an apartment, a house, condos, what have you. If repairs that are supposed to be made by a landlord are not made, and you want to withhold rent or you want to leave, you should talk to a lawyer first. And if something occurs like a hurricane and you want to withhold rent because you can't live there, talk to a lawyer, because you might be able to do it, but only if you follow the procedures in the statute. Now, I would not try to do my own plumbing. I don't know squat about it, and I really can't get down on my knees anymore. But a plumber can do my plumbing, hopefully an honest plumber, and hopefully you get an honest lawyer. But every one of us has areas of specialty and expertise. Every one of us has people in the family or friends that have areas of specialty or expertise. Don't do what you don't know how to do. And when it comes to the law, I submit to all of you that you walk through a landmine field if you try to do it yourself, except for small claims court, or even there, I will often advise people as to how to handle a case in small claims court and then let them go handle it themselves, because it's much more cost effective. So a couple other examples. Vermont, Delaware, and Hawaii. The limit on time to refund a security deposit. I often get this call. My landlord hasn't paid me my security deposit yet. And in Florida, I often have to tell them, you need to wait a little bit while longer. And we'll get to Florida. But Vermont, Delaware, and Hawaii. The limit on time to refund a security deposit is 60 days in Vermont and Delaware, 45 days in Hawaii. It's also 60 days in West Virginia and Arkansas. But 30 days in North Carolina. Very different, folks. In Florida, guess what? Will you be surprised if I tell you there's a very detailed statute on security deposit refunds? No, you're not going to be surprised. You know that that's where I'm going.
3 hours.
I'm as obvious as a streetwalker on a street in a neighborhood where you would expect to find a streetwalker. So in Florida, once you give your security deposit to the landlord has to provide you with a written notice within 30 days as to whether that security deposit is in a non-interest bearing or an interest bearing account, and must advise you of certain rights using the language in the statute, which is, if the landlord fails to timely mail your notice, the landlord must return the deposit, but may later file a lawsuit against you for damages. If you fail to timely object to a claim, the landlord may collect from the deposit, but you may later file a lawsuit claiming a refund. A lot of gobbledygook there. But what it's trying to tell you is that if the landlord doesn't give you that beginning of your tenancy notice within 30 days, the landlord can't claim any portion of your security deposit. It's waived it, it's given it up. But let's say the landlord does give you that standard notice with the proper language in a timely fashion, all things that we lawyers will look for in the event this becomes an issue. Now, what is the landlord's obligation in terms of returning the security deposit? Well, you may be surprised, much shorter than these other states. If the landlord does not intend to claim any portion of the security deposit for damages, it must return it within 15 days of you vacating the premises.
You know, and that's interesting you say that. When we moved here from LA, we rented a house. And the company that we rented from, of course, we wound up buying a house 3 years later. They went bankrupt. We got something from a law firm in South Florida. There's some massive lawsuit against these people.
Some class action.
Yeah, and you can pick up, it's not your whole security deposit.
It probably is a very small portion of your security deposit.
Yeah, probably. But you know, it's like, and I didn't know whether that was real or not. I mean, is it possible you can get some of it back?
It is possible if they go bankrupt that you may get some of it back. I wouldn't hold your breath.
Yes.
So what happens here now, if in Florida, if the landlord wants to claim any portion of the deposit as damages, or all of it, it must send you within 30 days a written notice telling you of the landlord's intention to claim a portion of the deposit. And you then have 15 days to object. If you object, the landlord cannot take anything and you cannot get anything. The matter has to be resolved in landlord-tenant court. If the landlord gives you the notice, I'm keeping $500 of the $1,500 security deposit, and you do not respond within the statutory period of time, then the landlord may keep the $500 and you're not going to be able to later claim that's not fair. So you'll get a notice as to your obligation to respond. If you don't respond, it's your problem. Now, if the landlord does not do it within 30 days, then the landlord cannot keep any of your security deposit. It must give it all back. So, lots of ins and outs and permutations. And that's why, when I was in my first year of law school in the 18th century, feels like that, they were talking to us in civil procedure class. I remember this very well. And they were talking to us about the importance of being hyper technical. People often claim that lawyers are hyper technical. That's because they've been trained to be hyper technical. Some judges get really pissed off at it. So what we were trained as an example is, let's say your client comes in and says, I was just served with a complaint. And they show you the summons and they show you the complaint. You are supposed to review that complaint, that summons, I mean, with a fine-tooth comb. Is it properly dated? Did the clerk sign it? Is your name misspelled? Instead of saying 20 days, does it say 22 days? If there is any defect in that summons, you tell the client, well, I can file a motion to quash the service of process based upon a defective summons, if you want to pay for that. Now, if the client says, look, they're just going to reserve me, and I'm going to have to answer this eventually, so let's just answer it, well, then that's what you do. But you at least give the client the option. But you have to look at these documents with a fine-tooth comb, looking for any defect, any mistake. Now, I will tell you that I have found mistakes like this quite often. I have only pursued them occasionally in bigger cases where clients wanted to make a point and told me, quash the service of process and make them do it again. And I can tell you that people have caught me on occasion with a boo-boo. And I got to then fix that boo-boo on my own dime. I'm not perfect either. Sometimes, I remember a subpoena that I had served for a deposition. And the address on the subpoena, served the person at such and such, was not where they found the person. And I had a lawyer file a motion because they were served at a location other than listed on the subpoena. Well, that's okay, because when it comes to serving subpoenas, you serve them at the address indicated on the subpoena or at any other location where you may find them. Now, we have this case going on in Florida right now, right? Where, well, not in Florida, one where they're trying to find Trump's cohort. Congress is trying to find him to serve him with a subpoena to testify before Congress. And he's trying to evade and hide. Well, anywhere they find this person, they can serve him. And plenty of people try to evade service of process. Without getting too far down the rabbit hole, when I was in college, I served process for a process server, and I was, trained how to do it. So I was able to tell process servers when I was a lawyer, you screwed up, because I would have done this. Did you? Anyway, I was camped outside somebody's house at 5 o'clock in the morning, waiting for them to come out on their driveway so I can serve them. And they knew they were going to be served, and they called the police on a suspicious car parked out in front of their house. The police come up, knock on my window. What are you doing here? I said, I am a process server. I showed my identification. I'm trying to serve Mr. Jones across the street. He's been evading service. And I'm just waiting for him to come outside, and I'm going to serve him. Now, some cops would have said, okay, and left. This cop said, move along. I guess a town friendlier to the homeowner. Another cop might have helped me do the service. There was another situation I had when I was trying to serve a subpoena in the projects in Newark, New Jersey. Now, I didn't realize what I was about to do. And I couldn't find the particular address. Couldn't see the numbers on the buildings. Why? Because all the numbers have been torn off. So I'm wandering around with my briefcase and my suit and tie. That's how our process server required us to dress. And a cop rolls by, stops in the middle of the street, rolls his window down. Back then, you rolled your window down. You just press a button. Rolled the window down and says, "Do you have a gun?" And I thought that was an odd question. And I said, "No, I don't have a gun." And the cop says to me, "Are you certain you don't have a gun?" And I looked at him and said, "No, I don't have a gun." He says, "And what are you doing here?" I said, "I'm here to serve a subpoena somewhere over there." Cop says, "You're white? You're dressed like that? I wouldn't do that if I was you. Not without a gun." Now I was a little scared. I was a lot scared. So I said to the cop, "Well, would you help me in serving this subpoena?" "Nope," and drove away. Well, I then got in my car. I drove away too. I went to the nearest, guess what, folks? You're gonna like this. I went to the nearest payphone. We didn't have phones in our cars. Oh, that thing wasn't invented yet. I went to the nearest payphone, put my dime in, called my boss, told him exactly what I just told you. And I said, "I'm not serving this subpoena." And he was a bit PO'd at me, but he did understand the circumstances. And so I guess somebody else was sent to serve the subpoena, maybe a big strapping linebacker type. That wasn't me for sure. All right, so we only have about 5 minutes left, and I have so much more I can tell you about land and tenant law and leases, and I'm sure you're all excited. I'm going to ask this in the last 5 minutes. Please don't let my mother be the only one to call this show today. 340-1590. I'm begging you. I'm pleading with you. Somebody call the show. So at least I never have to say, "Only my mother called." Come on, guys. I'm 61. I don't want my mother to be the only one who called the show. Dun, 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 dun. Dun, 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 dun. Dun, 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 dun. Dun, 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 dun. Do we have a caller? No?
Uh-oh, phone's ringing.
Is it ringing?
Oh, 2 lines are going.
Oh my gosh, thank you. 2 lines. Let's try to handle both of them. One at a time, though.
Oh, man. See, there is somebody out there.
Give me the first one, quick.
Well, people are talking on those lines apparently. Oh, wait a minute. Oh, wait a minute. Maybe both of them will be coming in here soon.
Coming around the mountain. Here she comes.
Well, maybe not. 3
No.
minutes left in the show.
3 minutes.
Oh, wait a minute.
We're getting a 3-minute warning here.
3-minute warning.
All right, time for the flea flicker. Hail Mary. Or in my situation, Leah, Sarah, Rebecca. Steve on line 1. Come on, Steve, quickly. What's your question?
Go ahead, Steve. Hello, Steve. We can't even hear you.
Yes, much easier to hear you now.
We can't hear you though.
Oh, no.
Oh, no. 2 minutes.
Steve?
Yeah?
Steve, can you yell and scream?
Yeah, speak louder.
Okay. Well, I mean, I assume you wanted to hear my question. So I have a question about landlord law, or necessarily, I guess, liability. I
You
haven't.
can hear, Greg. You can relay it to me.
Yeah, Steve, your line
Let's
is
go to the next one.
real poor. Okay, let's see. Let's try line 2 here. You're on with
Mystery caller, what's your question?
The question is, what do you know about adhesion law?
Adhesion law.
Uh-oh.
Adhesion contract.
I had to get a stumper. I don't know much about adhesion law at all.
Uh-oh, there we go. Stump
Oh, God, I
the
should never have
lawyer.
asked for calls.
Stump the lawyers.
Do we have another one?
Yeah, let's move. Let's move on. Okay, Jerry, you're on with the Stuart address you have.
Come on, Jerry, let's go.
Okay, thank you, Greg. Good morning, Stuart.
Morning.
I spoke about a year ago, so I'm kind of hard to understand. But I was wondering when there's a wildcat strike at say GE or someplace like that, where the workers will walk out, is there anything legally the management can do to stop that? I'd like to listen off air. That'd be okay, Stuart?
You're talking about workers walking off the job?
Wildcat strike is one way that management can stop a wildcat strike. I'd like to listen off air. If that'd be okay?
There's no union.
Yep. Well, it probably would have been in the case of GE.
Okay.
We're out of time, Stuart.
We're out of time. I will answer that next week on another edition of Ask the Lawyer, folks. Call in earlier this time, please. I'd rather talk to you.
This is
Have a good week.